Hello everyone, welcome back to day 7 of Polity Daily Drill. Let's begin the questions for the day. First up, consider the following cases. Appointment of the Prime Minister when no single party attains majority after elections to the Lok Sabha, exercising pocket veto, a temporary delay of an ordinary legislation even when the Lok Sabha has the confidence in the Council of Ministers, and dismissal of the Council of Ministers when it cannot prove the confidence in Lok Sabha. In which of the above cases is the President not bound by the advice of the Council of Ministers? Basically, we are referring to the idea where there is a sense of what? Discretion. In which all cases does the President enjoy discretionary powers? So of course, one is correct. Appointing the PM when no single party attains majority. What do we call a situation where no party gets majority? It is called a hung parliament. A hung legislature is a legislature where no party gets the majority after the elections. The same goes for number 4 as well. Dismissal of the Council of Ministers when it cannot prove the confidence in Lok Sabha in case you fail the trust vote or you lose the no confidence motion. Either way, the President can dismiss the Council of Ministers on his own. There is absolutely no need of anyone's advice. Exercising pocket veto is also a discretionary power of the Indian President, very famously used in the 1980s by Gyani Zail Singh. And number 3, a temporary delay of an ordinary legislation. See, the statement was just this much. What is this temporary delay? This is nothing but the use of suspensive veto. The other half did not really matter. This was the statement that you had to understand. So yes, suspensive veto is also what? A discretionary power of the Indian President. So all 4, hence D is the right answer. 1, 2, 3 and 4. Second question. Consider the following statements with regard to cabinet committees. They have been established under the Government of India Allocation of Business Rules 1961. Number 2, the Minister for Defence is the chairperson of the Cabinet Committee on Parliamentary Affairs. Now, just to be very clear here, under Article 77 Clause 3, the President can make rules for the convenient transaction of business and also for the allocation of business amongst the ministers. Now, there are 2 rules. Number 1, Government of India Allocation of Business Rules. These rules contain ministries. And the second rule is the Government of India Transaction of Business Rules. These rules actually contain the various or 8 permanent cabinet committees. So statement 1 is wrong. They have been established under the Government of India Transaction of Business Rules and not the Allocation of Business Rules. Second one, the Minister for Defence is the chairperson for CC on Parliamentary Affairs. This is absolutely correct. Since 2019 itself, the Defence Minister is the chairperson for the Cabinet Committee on Parliamentary Affairs. It is not the Home Minister. Some books might still contain this information. This is old information. Since 2019, the Defence Minister heads the CC on Parliamentary Affairs and the Home Minister heads the CC on what? CC on Accommodation. Whereas the remaining 6 cabinet committees are all chaired by the Prime Minister of the country. So 2 is correct, 1 is wrong. Which of the statements given above is or are incorrect? A1 only is incorrect. Moving on to the third question. Which of the following statements with respect to Article 249 of the Indian Constitution is correct? We had seen a question on Article 249 yesterday itself. I hope that you will mark this answer correct, and I do hope that you have read the article on your own. So, Rajya Sabha can authorize the Lok Sabha to make laws on stateless subjects. This is of course incorrect. Rajya Sabha can authorize not Lok Sabha but the Parliament. Why just the Lok Sabha? Whenever the Rajya Sabha authorizes the Parliament and a bill is brought to make a law on a stateless subject, the bill goes through the exact same procedure as any other ordinary bill, right? It must be passed in the Lok Sabha, in the Rajya Sabha with a simple majority. So of course, A is wrong. Such authorization shall remain in force for 1 year at a time. Now this is correct. Authorizations given by Rajya Sabha will remain in force for 1 year at a time, but yes, that's also true that it can be renewed any number of times. That's also allowed. This would mean that C and D are of course incorrect statements. The Parliament must make laws. No, it is not mandatory for the Parliament to make laws. And laws made by the Parliament under such an authorization end as soon as the authorization comes to an end is also wrong. Why? Because it ends 6 months after the end of authorization. Hence, B is the right answer for this question. Moving on to the fourth question. Which of the following statements regarding judges of Supreme Court is incorrect? The senior most judge of the Supreme Court shall or should be appointed to the office of the Chief Justice of India. This is correct. We know very well the system known as the collegium process states very clearly that the senior most Supreme Court judge will become the Chief Justice of India. It is mandatory for the President to consult Chief Justice of India during appointment of other Supreme Court judges. Yes, it is mandatory. The Chief Justice is a part of the 5-judge collegium. In fact, the Chief Justice not only is just a part, but also has the veto power. Constitution has prescribed 45 years as the minimum age for appointment as a judge of the Supreme Court. Now, this is wrong, of course. And also our answer, there is no minimum age, there is no tenure. The only thing that is mentioned in the Constitution is the age of superannuation, or as you would say, the retirement age. And what is the retirement age? The retirement age is 65 years. 65 for Supreme Court, and initially 60, later on increased to 62 years for the High Court judges. So C is the answer here, which is a wrong statement. And let's look at the fourth one. Only a citizen of India is eligible to become a judge of the Supreme Court. Yes, that's also correct. So here, C being the wrong statement is the right answer. And the last question for today. Consider the following statements about Article 17 of the Indian Constitution. Article 17 allows the practice of untouchability for only essential religious practices. The Constitution explicitly, meaning clearly, provides a definition of untouchability within Article 17. And number 3, state legislatures can make laws providing for punishment for enforcing untouchability. So Article 17 deals with untouchability. And let me just clarify one thing here. There is no exception to untouchability. Whether it's some religious practice, historical practice, you cannot justify untouchability on any ground. There is no exception. This is an absolute restriction. So Article 17 is more of a restriction than a right, and it is absolute in nature, absolute restriction. So even if it might have been a part of your essential religious practice, untouchability can never be allowed. So statement 1 is incorrect. Statement 2 is also incorrect. There is no definition of untouchability mentioned in the Constitution. And number 3 is also incorrect. Why? Because yes, laws need to be made to provide for punishments for the offense of untouchability. We have a law that is known as the PCRA, Protection of Civil Rights Act, but this law is made by the Parliament, and the Parliament is allowed to make laws to punish for the offense of untouchability. This is as per Article 35 of Part 3 of the Indian Constitution. How many statements are correct? None of the statements given here are correct. So that is it for today. We'll meet in the next video. Till then, that is all for me for this video. Jai Hind.